say no. She did answer my question by describing what the allegation was, and it didn't include any use of force. Further, we've got this child that's like a 4-month-old, so it's sort of contrary to common sense that you would have to use force on him anyway. And ultimately, it was just undisputed that that the only legal dispute here was whether Moats was the father. It wasn't whether there was force. So it was undisputed that this State versus Goodman defense would apply if he's the father, but then there was the question, well, is he the father? Is he a caretaker? And so while I wish I had made the indictment part of the record, I feel like the court should be able to address that regardless. If for whatever reason the court felt like the factual findings weren't adequate, I do believe that the proper remedy would not be to dismiss the post-conviction, but rather would be to remand for the post-conviction judge to make findings on that if we feel like it's too late.
Because how can we determine whether counsel was deficient if we don't know how the defendant was charged?
What I'm saying is we can tell how the defendant was charged by the testimony and by the fact that it wasn't ever challenged. I mean, she said what the allegation was, and so, I mean, everyone accepted that as reality. No one said, well, you're lying about what the indictment said. So I submit we do know how he was charged.
But I guess the question I still have, though, is it's the petitioner's job to present the evidence in a post-conviction.
Correct.
And if the evidence isn't there, you can say we can glean this from that and we can glean it from that, or the state didn't object. But if you didn't put the evidence before the court and it's not now before us, how do we know that he wasn't charged that way? And it's force, threat, or fraud. Correct. So, I mean, you know, without seeing it and without seeing the guilty plea and those types of things, how do we really know how he was charged and what he pled guilty to?
We know, I mean, unless we're to assume that this witness was lying, which the post-conviction trier of fact never found, then we know what the allegations against him were.
So what was her, then refresh my memory on how she responded to your question of was there force?
I don't have the full quote right in front of me, but it was on pages 12 and 13. I've written down of the post-conviction hearing transcript, and I asked her what the allegations were. The allegation was that he took the child for, I believe she said, 4 hours, drove off with him, and then brought him back. And you know, to use, I'm not sure how you could even use fraud against a 4-month-old if the child doesn't even really, you know, isn't old enough to even speak English, essentially. I don't know how you could use a threat against him either. Using force against him, it's maybe possible, but it's highly unlikely because it wouldn't really make much sense.
I mean, obviously it's going to come down to how she testified, but what you just said doesn't prove he wasn't charged with force. That's just her summation of what the facts were. There's a difference between what the prosecutor or the defense attorney says, here are the facts, versus what the indictment read.
Well, ultimately, what matters is not, I guess, what the indictment said so much as what the proof would have shown. And so if the proof would have shown what she alleged, then he would have been found not guilty. Okay. And if he weren't found not guilty, he would have challenged the insufficiency of the evidence to your honors, and then y'all would have found him not guilty. And so, assuming again that no force is even really at issue here, I mean, again, this isn't something the state even came up. I tried to look back at the state's answer to where I had pled in my post-conviction hearing, you know, what the charge was, and the state just did one of these answers where on virtually every paragraph they just said denied and strict proof demanded or whatever. But I mean, once you got to the hearing, everyone seemed to agree that he wasn't charged with using force. He was charged under the section where State versus Goodman would apply if he's a parent. And so the question is, was he the parent? In terms of reasonable probability of prejudice. Moats testified he would have pled not guilty if he weren't given this advice. The public defender testified she gave him this advice, and then he pled guilty. There was also testimony from Moats that, at least in his opinion, the other charges were weak, and so, and even if he were found guilty of the other charges, he wouldn't have faced any all that scary of a punishment in his view. And so there's no reason to doubt his testimony that he would have pled not guilty but for this error. As far as the deficiency and whether it was deficient, trial counsel admitted that she advised him in this way. We've submitted that she misadvised him, and further that she misadvised him because she did not even do basic research on this topic.
Well, she didn't actually say she misadvised him in her testimony, did
Right.
she?
No, I said she admitted she advised him in this way, and we're saying she misadvised him.
But she also testified that he told her he lied on the form,
Right.
the paternity form.
Correct.
And she knew he was not the biological father.
Correct. And we're saying that that doesn't matter, and that if she had looked at the statute, not to mention the cases citing the statute, she would have seen that that doesn't matter. False imprisonment requires that the confinement be unlawful. The statute 3913-30115 says unlawfully is defined as being taken without the consent of a parent or other person responsible for the child's supervision, or with, by force, as we've talked about. Here, everyone, as far as I can tell, fully agrees that Mr. Moats, at minimum, was fully responsible for the child's supervision, and that he was acting as a parent, and that both of them had been acting as though he were the parent. So it seems like that would fit regardless of whether he's legally the father. But moreover, under the statute we've cited, he was legally the father as a matter of law. Trial counsel knew that the state had identified Mr. Moats as the father on the birth certificate.
But that doesn't make him the father.
By law, under the statute, the birth certificate is connected with a voluntary acknowledgement of paternity.
Which also, the voluntary acknowledgement of paternity says you are the biological father, and he's not. So the form is not valid.
Well, under the statute 24-7-113, Your Honor, respectfully, the form is valid unless it's rescinded or countermanded by a court in some way. The statute says, this acknowledgement, unless rescinded pursuant to subsection C, shall be conclusive of the father's paternity without further order of the court. And so if it's conclusive, then I'm not allowed to say.
So if I lie on a form, the form is legal, even though I committed fraud in filling out the form.
Essentially.
And it has an affidavit that says you swear that the
Right.
information is true, and you acknowledge that it was not true. I mean, so can anybody just go sign one of these forms and then start taking children, and it's okay, under your argument?
And add to that the court has said these are not to be used as a way to circumvent the adoption law. So the point is, you have to be the biological. You can't just say, hey, I want to take responsibility for this child, so I'm gonna sign one of these. You have to be the biological father under the form, because otherwise you could circumvent the adoption laws.
To address y'all's questions, is it legal? That sort of depends on exactly what you mean by legal, because it's not legal in the sense that it is wrong. It could subject you to a criminal charge of perjury. It can be countermanded later by a court. It is legal, however, in the sense that the form carries legal power. The act of signing the form carries legal power. And so what the court said in re CAF was the normal operation of Tennessee Code Annotated 24-7-113 makes it possible for an unwed mother to confer a constitutionally protected parental status upon any male willing to sign a voluntary acknowledgement of paternity. And so what that means is, once that's signed, he becomes the legal father until.
So let me change the hypothetical then.
All right.
I'm 16 years old, and I sign a contract with Judge Montgomery saying I'll pay him $1 million. Is that contract legally enforceable?
I don't know quite enough about
Well,
contracts.
I mean, I'm a minor. I can't do that. I have to be 18 in order to enter into a contract with him. So even though on the contract, on its face, it looks legally enforceable, to your argument that it can be legal and illegal, it's not legally enforceable. And if this document says, I swear I'm the biological father, and you sign your name and that's not accurate, you can tell me all you want that the statute says it's a legal document, but it's not a legally enforceable document.
What the statute says is that it is a legally enforceable document, and there are a few outs. So one out you've got to stop the legal enforceability is within 60 days you can rescind your signature.
So I get this, but I'm having trouble with you telling us that it's okay to misrepresent and perjure yourself in a sense on a document, and it's still legally enforceable when the law makes it clear that if you swear to something being true and it's not true, then it's not legally enforceable. In
re CAF talks about the fact that if the power is abused, it can be undone, but until it's undone, it's still in effect. There's still power. Other than the 60-day rescission period, there's also another 5-year period where the signer can try to undo it based on fraud or some other grounds. And then the courts have also held that the Department of Children's Services can file its own petition based on fraud to try to undo this document. But the fact of the matter is, until those are done, you are legally the father. The courts have specifically said that the legal father is not necessarily the same as the biological father. And so what that means is you can be the legal father even if you're not really the biological father until that's undone. That could have been because you committed fraud. It could have been because your lady committed fraud on you and misled you. Could be because y'all were just mistaken. One way or another, the document carries power, and if that power is misused, then that just means you undo it. The evidence here is clear that the document has never been undone, rescinded, or in any way undone, even today. So even today, he is still conclusively the father, and we're not allowed to hold otherwise or say otherwise. Certainly it hadn't been undone at the time of this supposed kidnapping. So for those reasons, I submit ineffective assistance has been shown. I will come back for rebuttal.
Good morning. May it please the court. My name is Will Lundy, and I represent the appellee of the state of Tennessee in this appeal. And, excuse me, I want to start by addressing some of the arguments that the petitioner has made. First of all, as the court noted, the state has said that the record is simply not adequate on appeal to allow this court to review the defendant's arguments. And the reason for that is that in Goodman, the question is not about whether the proof would have shown one thing or another. Goodman, just based on its procedural posture, was about a Rule 12 motion to dismiss an indictment prior to trial. And so the question in Goodman is whether the indictment itself is sufficient to essentially charge the crime of especially aggravated kidnapping for the person who happens to be, a biological parent of the child. And in order to get in under Rule 12, there has to be no real finding of fact that the court has to make. Rule 12 motions, as the court explains in Goodman, are typically, rulings on questions of law, not questions of fact. And so, again, the question is, what was he actually charged with in the indictment? And absent that indictment, I think the record is inadequate here. But let's assume for the time being that the record is adequate. In other words, that the petitioner can get into these voluntary acknowledgement of paternity arguments and actually, make his case on that basis. The state's position is, just to make matters simple, Goodman itself is very limited to its facts. Again, part of that is because it was on a Rule 12 motion. And in Goodman, the parent there was unquestionably the biological father of the child. Neither this court nor the Supreme Court has ever considered the effect of a perjured or fraudulent voluntary acknowledgement of paternity on whether or not a person can be charged under the with kidnapping under the definition of unlawful and all of those kinds of things. And so counsel, Ms. Kilgore, was not ineffective for failing to raise what would otherwise be an issue of first impression. This court has repeatedly held that counsel is not ineffective, for failing to anticipate changes in the law that may or may not occur. So, for that reason, Your Honors, the voluntary acknowledgement of paternity, the petitioner can't show that trial counsel was ineffective. And as I think, Judge Ayers, I believe, as you pointed out, counsel did say that she knew about Goodman. She knew that Goodman existed. She knew that under Goodman, you had to be the biological father of the child in order to qualify for that immunity. And I want to be clear, again, we're talking about an immunity from charge under Goodman, not a defense to be raised at trial. Those are two separate legal questions. And, as limited as Goodman has to be based on its procedural posture, it really only applies to biological parents, at least by its explicit language. And therefore, when she knew that the petitioner was not the biological father of the child, she reasonably, I believe, inferred that he could be charged with kidnapping and that he faced a very serious penalty. In this case, he was looking at 25 years in prison at 100%, and she was able to negotiate a plea with the state that got him down to 3 years at 30%, which, if my math is right, that's 10 months and 24 days. So that's significantly less than what he would have had if he had been convicted at trial.
What about the petitioner's argument, though, that based on counsel's statement of how the facts played out, that if he was the biological father, that there was no force, coercion, fraud, and therefore it would have applied, and she should have, at least had that discussion with him of, hey, I know you're not the biological father, but we have the document that says you're taking responsibility. Goodman gives you a defense. If these cases, and then the facts are, you just took the kid for 4 hours and brought him back. How do you respond to that?
And I guess I'm sorry, Your Honor. I'm not sure, because you said at one point that you were asking if he was the biological father. Then you said he didn't. Can you clarify your question? I apologize.
Yeah, so the defendant's argument is a couple of things here. The defendant's argument is that the document made him basically the biological father.
Right.
Oversimplifying it, but basically made him the biological father. Okay. Counsel's recitation of the facts are that there was no force, threat, or fraud in the kidnapping. At least that's the defendant's argument, that her recitation is he just took the kid. Okay. Under those circumstances, even though she knows he's not the biological father, but his argument is that he is, she still advised him that Goodman didn't apply, where there's an argument that Goodman could apply. So how do you respond to that? That's basically his argument.
Right.
Overly simplified, but that's basically his argument.
Yep, and my response is that, he never said he was the biological father, and he never argued that he was the biological father. He's saying that he became the father by means of this perjured document that he signed. And so to go to that point, Your Honor, I would like to just point out the language of Section 24-7-113. And the statute says, if I can find it in my notes, that, there it is, that it explicitly says that the voluntary acknowledgement of paternity shall be a basis for establishing a support order without requiring any further proceedings to establish paternity. So the statute itself tells us this is what this voluntary acknowledgement of paternity does. These are the rights, essentially, that accrue to you for signing the VAP. Essentially, it's a right to pay child support. And in fact, that's what CAF actually held. In CAF, the court said the main purpose of this statute is to allow the court to enforce a child support order. And one of the things with CAF, we have to, when we look at it, the court actually held that trying to circumnavigate the adoption statutes is contrary to public policy. And so insofar as it held that, I think it's reasonable to reason out that whatever rights you get under a VAP, a voluntary acknowledgement of paternity, I'm sorry, that's a lot of words, but whatever rights you obtain under that must be subject to public policy considerations. And here, public policy would weigh very strongly against that because we're talking about perjury. And the other thing that CAF doesn't do, so in CAF, there were 3 people who were having their parental rights terminated, one of whom was, like the petitioner, a man who had perjured this voluntary acknowledgement of paternity. And the big question in CAF was whether DCS had standing to challenge this voluntary acknowledgement of paternity. And the court held that yes, DCS does have that standing. So what CAF doesn't do, and I think what petitioner is arguing is, he has all of the rights that a parent would have under the law because he signed this acknowledgement of paternity form. But if that were true, as the court is well aware, parental rights can only be terminated. True constitutional parental rights of a natural parent can only be terminated after a termination of parental rights proceeding. What CAF doesn't do is say, now DCS, you can, after you challenge the voluntary acknowledgement of paternity, you're going to have to get into a termination of parental rights in order to get rid of the rights that he has. So in a case that the petitioner cites, it's In re James T., he cites it in his brief, the Court of Appeals held that a man who had perjured a voluntary acknowledgement of paternity and whose paternity had been disestablished by the rescission of the VAP can simply be dismissed from a termination of parental rights proceeding. And the reason for that is simple. The man has no parental rights. What the voluntary acknowledgement of paternity does is it permits the court to enforce a child support order. And so, and that gets down into the weeds, right? The main point is that Ms. Kilgore was not required to make this argument in order to be constitutionally effective. This is an argument, again, it's detailed, it's complicated. Quite frankly, as a lawyer, I think it would be a lot of fun at the Supreme Court. But, but it's not something that she was required to make in order to be constitutionally effective, excuse me. If the court has no further questions, I would ask that the court affirm the post-conviction court, and otherwise I'm content to cede the remainder of my time. Thank you, Your Honors.
So to be clear, the statute that trial counsel never looked at says that the acknowledgement shall be conclusive of the father's paternity without further order of the court. If you go to merriam-webster.com, the word conclusive means 1, of, relating to, or being a conclusion, or 2, putting an end to debate or question, especially by reason of irrefutability. So even if the state had been able to elicit testimony that Mr. Moats wasn't the biological father, which we don't really have any reason to think they even could have. The only person who revealed this to the court was trial counsel on post-conviction. It's still irrefutable. Even if we know that biologically he's not the father, it's, as a matter of law, irrefutably conclusive that he is the father. The Supreme Court in re TKY said the legal father may or may not be the biological father of a child. Here, Mr. Moats is the legal father, even if the state had been able to elicit testimony saying that he wasn't really the biological father because he and the mother had lied.
What about the argument that this is a kind of an issue of first impression, and you know, the courts have held that you're not deficient for not raising an issue of first impression?
I'm not aware of a specific holding that counsel are not required to present an issue of first impression. However, even if that were the case, I just submit the plain language of the statute agrees with my interpretation, and I've cited multiple court cases in the civil context that distinguish a legal father from a biological father, and so those also agree with my position. And the U.S. Supreme Court in Alabama versus Hinton talked about a failure to do basic research, and specifically not involving court cases, but involving a statute. They said, Hinton's attorney knew that he needed more funding to present an effective defense, yet he failed to make even the cursory investigation of the state statute providing for defense funding that would have revealed to him that he could receive reimbursement, not just for $1,000, but for any expenses reasonably incurred. And then they said, an attorney's ignorance of a point of law that is fundamental to his case, combined with his failure to perform basic research on that point, is a quintessential example of unreasonable performance under Strickland. Here, trial counsel was ignorant of this statute, which was, everyone seems to basically agree that it was fundamental to the defense. She knew of the Moats doctrine that you could claim a defense as the parent, and yet she failed to perform basic research about the legal effect of this statute in declaring him to be the parent. There's other ways to be a parent other than being a biological father. You can adopt, I think that's the main other way, is you can sign that form, or you can adopt. Or you can actually be the biological parent. But the case of State versus Goodman, it didn't say, well, you have to be the biological parent in order to raise this defense. It didn't say, well, if you're the adopted father, you can kidnap your own child. It didn't say if you signed a voluntary acknowledgement of paternity, then whether you can kidnap the child depends on whether the state's able to DNA test it later and figure out whether you mistakenly signed it or whether you perjured yourself or whatever. The doctrine, the State versus Goodman defense is just citing the definition which calls you a parent. And so the same definition would make you a parent whether you're an adopted father, whether you've signed the VAP, or whether you're biological father.
Would you maybe you won't, but would you agree there's a difference between there could be a difference between a biological father and an adopted father versus someone who just agrees to pay child support for a child?
I don't agree that there can be differences because a biological, no, actually I would say no, there is not a legal difference until it's rescinded by a court. I was going to say that an adopted father typically has some form of custody of the child, whereas a VAP signer might not, but that's not always true. So I would say that legally they are all equivalent until it's been rescinded or countermanded by an order of the court. And in terms of whether it's an issue of first impression, the fact is the petitioner was entitled to be notified of this doctrine and not misadvised about it due to ignorance. He got to make the decision of whether to plead guilty. It should have been an informed one. So we would ask for that the post-conviction judgment be reversed and he be granted post-conviction relief. Thank you.
All right. Madam Clerk, would you hear me?
I'm good.
Would you call up the next case, please?
State of Tennessee versus Curtis W. Bradley.